C coming in as 3, video of scene walkthrough. States D through NN, 2N will come in as states 4 through 40. Those are individually labeled crime scene photographs with descriptions on the evidence list.
Have those been printed or are they on disc? Okay.
I'll be displaying them with a PowerPoint, but I do have binders for all the photographs. They're all printed and individually labeled.
All right. Thank you.
States 00 through EE will come in as states 41 through 57, evidence technician photographs. States FFF through III will come in as states 58 through 61, surveillance still shots. JJ will come in as states 62, identity photo of Jared Bridegan. States 3K through 3I will come in as 63 through 87, medical examiner photographs. Quadruple J will come in as 88, composite 10mm cartridge casings. 4K will come in as 89, composite of projectiles recovered from victim's vehicle. 4L will come in as 90, tire from crime scene. 4M coming in as 91, a surveillance video compilation DVD. 4N is 92, swab from tire from crime scene. 4O coming in as 93, composite projectiles recovered during the autopsy. 4P coming in as 94, blood card from medical examiner's office. 4Q coming in as 95, buckle swab Henry Tenon. 4R coming in as 96, buckle swab Mario Fernandez. States 4S through 4U coming in as 97 through 99, photographs from recovery of tire at 5239 Potomac. 4V coming in as 100, tire collected from Potomac. 4W through 5U coming in as states 101 through 125, evidence technician photographs, search warrant on Potomac Avenue. Each photograph is printed, described in the evidence list, and individually labeled. States 5V is 126, cool pad cell phone. States 5W is 127, LG cell phone. States 5X is 128, jacket from garage at Potomac Avenue.
Good morning, everybody. You have not missed a thing. Hi, Jerry. Yeah, I don't know what they're doing. They're reading items of evidence. Not sure why they're doing that, but they have not done opening statements yet. So stay tuned. I'm going to go get a cup of coffee.
1705 University Street and the Jacksonville Beach Police Department impound lounge lot. Those are printed and individually labeled. 7K coming in as 167, check stubs. 7L coming in.
Wait. So 7K. What did you say 7K was?
Check stubs. J is 166.
Okay.
That's the
All right.
tail end of those
Got it.
photographs.
Thank you.
7L 168, box for boots. 7M 169, swab from steering wheel. 7N, a composite CD of financial records, Fernandez and Gardner. 7O coming in as 171, composite CD financial records, Tenon. 7P coming in as 172, composite CD financial records, John Biggerstaff. 7Q coming in as 173, composite documents from Department of State, First Choice Home Rentals LLC. 7R coming in as 174, composite receipts and documents from Discount Tires. 7S coming in as 175, composite Department of Transportation records, DOT numbers, Michelin tires. 7T coming in as 176, certified marriage license. 7U coming in as 177, vehicle registration, Ford F-150. 7V coming in as 178, a composite disc of call detail and toll records, T-Mobile, Fernandez. 7W coming in as 179, composite call CD, call detail records and toll records, T-Mobile Tenon. 7X 180, composite disc, call detail and toll records, AT&T John Bigger. 7Y will come in as 181, a composite CD, Google location data records, Henry Tenon. 7Z coming in as 182, a composite FBI cast cell site maps. 8A coming in as 183, recorded interview of Mario Fernandez, and we'll need the redaction instruction for that, Your Honor. I'll remind the court at the time. 8B will come in as 184, cell phone, A13, Mario Fernandez. 8C coming in as 185, once Ms. Day is done reviewing it. 8D coming in as 186, composite binder.
Has it been marked?
I'm sorry, I believe it has been marked. They're just checking to ensure that the records on the disc match those that were sent.
Okay, sorry about that. All right, keep going. So you were in 186.
186, Cellbrite device extraction reports and Google reports, Henry Tenon. 8E coming in as 187, a composite binder, Cellbrite extraction and Google reports, John Biggerstaff. 8F coming in as 188, recorded audio from wire intercept, call 557. 8G coming in as 189, recorded audio from wire intercept, call 1035. 8H coming in as 190, firearms inventory sheet. 8I coming in as 191, a composite ATF certified firearms trace and purchase records. 8J coming in as 192, vehicle keys for Ford F-150. 8K coming in as 193, swab of keys. 8L coming in as 194, composite DVD, body-worn camera footage, Henry Tenon. 8M coming in as 195, composite receipts from Walmart, Pennsylvania. 8N coming in as 196, composite family law docket and filings, St. John's Clerk of Courts. 8O coming in as 197, composite exhibit, notebook and paperwork recovered from garage at Potomac. 8P coming in as 198, Google Map, Jacksonville Beach. 8Q coming in as 199, Google Image, Potomac Avenue House. 8R coming in as 200, booking photograph of Henry Tenon. 8S coming in as 201, photograph of Shanna Gardner. 8T coming in as 202, Google Image of Sanctuary, Google Map. 8U coming in as 203, DVD surveillance flash drives with DVD surveillance clips. 8V coming in as 208, Google Image route, Wendy's to Marsh Inlet. 8W coming in as 205, Google Image, Marsh Inlet House.
Wait a minute. So 8V, you said 208.
204,
Okay,
I'm sorry.
all right.
Google route to Wendy's to Marsh Inlet. 8W 205, Google Image Marsh Inlet House. 8X coming in as 206, phone number chart. And then 8Y coming in as 207, photograph of Fernandez and Gardner.
Okay, Mr. Dreiser for the defense.
Good morning again.
Good morning. Do you have a list or I can just write it?
It's a lot. I think this is an extra matching list. If not, I'll print you one. If somehow
Okay.
one in the binders don't match, I'll print you another one.
Okay.
So we have exhibit letter A through I, which comes in as 1A through 1I.
Oh, okay. It's in composite.
Yes, ma'am, but we did break the composites up, so it's clear. Would you like me to read what they are? The record?
Yes, for the record.
1A, St. Johns County dissolution of marriage docket, referred to as DOM. 1B, consent final judgment, dissolution of marriage. 1C, former wife supplemental petition to modify parental responsibility timesharing. 1D, former wife supplemental petition for modification of timesharing support. 1E, former husband's motion for school determination and request for indicted hearing. 1F, former wife's consent order regarding school choice. 1G, former wife's motion for declaratory relief. 1H, former husband's response for mother's motion for declaratory relief. 1I, consent order on mother's motion for declaratory relief. Exhibit letter B coming into evidence as 2 is the postnuptial agreement. Exhibit letter C coming in as evidence 3, irrevocable trust agreement. Exhibit letter D coming in as evidence number 4, composite receipts from Pennsylvania trip, Walmart, Ruby Tuesday, Spring Hill Suites. E coming in as evidence number 5, bigger staff order setting conditions of release. F coming in as number 6, T-Mobile interpreting records packet. G coming in as number 7, evidence technician, otherwise referred to as ET, photo Potomac Ave house, living room / front entryway. H coming in as number 8, evidence technician, photo Potomac Ave house, living room table. I coming in as 9, evidence technician, photo Potomac Avenue house, boots / router. J coming in as 10, evidence technician, photo Potomac Avenue house, lease agreement. K, which has a composite of 11A and 11B. So K coming in as 11A would be composite, 2 ET photos, Potomac Ave house, green camo jacket, which was located in the garage.
Okay.
K coming in as 11B, composite, 2 evidence technician photos, Potomac Ave house, tan jacket and garage. L coming in as 12A, composite, 2 ET photos, Potomac house, tan jacket. Did I just read that incorrectly? Did I double?
No, so 2A is 2 photos, but found a tan jacket in the garage and then tan jacket post-collection
Yes.
is
thank you.
composite.
Yes, thank
Okay.
you. M coming in as 13A is a composite. It's 2 evidence tech photos, Potomac Ave house, tan sweatshirt in closet. M coming in as 13B, composite, 2 evidence technician photos, the Potomac house, tan sweatshirt post-collection. N coming in as 14A is a composite of 3 evidence technician photos, the Potomac house, boots, black and tan boots. N again coming in as 14B, composite, 3 ET photos, Potomac house, boots, tan boots. N coming in as 14C, composite, 3 ET photos, Potomac house, boots, 1 tan boot, 2 black boots. O, which is a 15A through
C.
15C. A being composite, 3 ET photos, truck, processing, boots, boots in truck, passenger side. 15B of composite, 3 ET photos, truck, processing, boots, boots in truck, driver side. And 15C, composite, 3 ET photos, truck processing, boots, post-collection. Exhibit P coming in at 16, ET photo, Potomac Ave house, outdoors, side of house. Q coming in at 17, ET photo, Potomac Ave house, checkbook. R, 18 as coming in as 18A, and there's an 18B through C. 18A is a composite of 3 ET photos, Potomac Ave house, Home Depot receipt on floor. 18B is composite, 3 ET photos, Potomac Ave house, Home Depot receipt, post-collection, front bedroom. 18C, composite, 3 ET photos, Potomac Ave house, Home Depot receipt, post-collection. S coming in as 19A through 19B. 19A specifically is a composite, 2 defense photos from evidence view, rental agreement, first page. 19B, composite, 2 defense photos from evidence view, rental agreement, second page. Exhibit T coming in as evidence 20, defense photo from evidence view, value pawn and jewelry papers. U coming in as 21, defense photos from Evidence View Advance America Papers. V, which is comprised of 22A through 22E. 22A is a composite of 5 defense photos from Evidence View Palette Ledger, page 1. 22B is composite 5 defense photos from Evidence View Palette Ledger, page 2. 22C is a composite of 5 defense photos from Evidence View Palette Ledger, page 3. 22D, composite 5 defense photos from Evidence View Palette Ledger, page 4. And 22E is composite 5 defense photos from Evidence View Palette Ledger, page 5. W, coming in as evidence number 23, is a defense photo from Sanctuary Boulevard, Jacksonville Drive. X, coming in as evidence number 24, is defense photo from the intersection of Sanctuary Boulevard and Jacksonville Drive. Y, defense number 25, defense photo from scene described yellow sign. Z, coming in as evidence number 26, defense photo from Pablo Hamlet parking space. Double A, coming in as 27, defense photo from Pablo Hamlet neighboring complex. BB, coming in as 28, defense photo from Pablo Hamlet smoking area. CC, coming in as 29, defense photo from Pablo Hamlet main building. DD, coming in as number 30, defense photo from rear of Marsh Inlet property. EE, 30, coming in as 31, composite external pole camera surveillance. Just so the court's aware, there is a composite of terabytes of pole camera. We admitted all of it, and then specifically we identified the clips that are likely to be shown as exhibits and small clip exhibits. So you'll see, I think that'll make sense later, but all of it's in, and then it's identified per what we expect to show the jury at trial.
Okay.
So FF, coming in as exhibit number 32, is a composite. It's 3 clips from Potomac pole camera, August 27th through August 29th, 2022, and it's labeled Biggerstaff because we believe that Mr. Biggerstaff is present for those pole camera clips. GG, coming in as 33, composite 20 clips from Potomac pole camera, August 9th through September 13th, 2022, Fernandez. HH, coming in as 34, a composite 16 clips from Marsh Inlet pole camera, March 13th through April 9th, 2022, Fernandez. II, coming in as number 35, a composite 3 surveillance clips from 25 Fairway Lane, 2/16/22 between 6 p.m. and 7 p.m., between 7 and 8 p.m., and 8 p.m. and 8:37 p.m. JJ, coming in as 36, is a composite of 6 surveillance clips from 65 Fairway Lane on 2/16/2022.
You don't have to go through the times, I don't think.
Yes, ma'am. KK, coming in as number 37, is a composite of 4 surveillance clips from 101 Penman Road South, which is the police station, on 2/16/2022. LL, coming in as number 38, a surveillance clip from 882 13th Avenue South on 2/16/22. MM, coming in as 39, surveillance clip from 901 7th Avenue South, Jack's Refrigeration, 2/16/22. NN, coming in as 40, surveillance clip from 1200 Shetter Avenue, Public Storage, 2/16/22. OO, coming in as 41, surveillance clip from 1202 12th Street South, Builder's Choice, 2/16/22. PP, coming in as 42, composite 2 surveillance clips from 1600 Shetter Avenue, Pablo Hamlet, on 2/16/22. QQ, number 43, a composite of 4 surveillance clips from 1712 Beach Boulevard, which is Taco Lou on 2/16/22. RR coming in as 44, a composite 3 surveillance clips from 2705 American Avenue, 2/16/22. SS coming in as 45, composite 3 surveillance clips from 2720 America Avenue, 2/16/22. TT coming in as 46, composite 3 surveillance clips from 2743 America Avenue, 2/16/22. UU coming in as 47, composite 3 surveillance clips from 3521 America Avenue, 2/16/22. VV coming in as 48, surveillance clip from 3724 Sanctuary Way South, 2/16/22. Additionally, I don't know that, and then there's some that's electronic that was contained in that and some that was paper.
Okay.
That's it.
And so from WW on, it doesn't, to W.
I'm not sure I understand it.
My list continues.
Okay.
WW is a composite of 13 exhibits. I'll hand it back.
Yeah, we added this morning, so that's probably not the additional ones that have been added. They're in, I assume. May I see that?
Yes.
I think you just have the updated list.
Okay.
Shannon. We weren't adding anything. That wasn't a.
Okay.
So I left off on double V.
I believe so, yes.
Double W coming in as 49. Composite 13 surveillance clips from 3940 Grande Boulevard, 2/16/22. Double X coming in as 50. Composite 3 surveillance clips from 4067 America Avenue, 2/16/22. Double Y 51. Composite 6 surveillance clips from Ocean K HOA, 2/16/22. Double Z coming in as 52A through 52K. 52A, composite 11 ET photos of swabs taken from the Ford F-150 steering wheel. 52B, composite 11 ET photos of swabs taken from Ford F-150 back passenger door. Double 52C, composite 11 ET photos of swabs taken from Ford F-150. 52D, composite 11 ET photos of swabs taken from Ford F-150 driver's back seat. 52E, composite 11 ET photos of swabs taken from Ford F-150 driver's headrest. 52F, composite 11 ET photos of swabs taken from Ford F-150 driver's seat. 52G, composite 11 ET photos of swabs taken from Ford F-150 front passenger headrest. 52H, composite 11 ET photos of swabs taken from Ford F-150 front passenger headrest zoom out. 52I, composite 11 ET photos of swabs taken from Ford F-150 driver's side window panel. 52J, composite 11 ET photos of swabs taken from Ford F-150 rear driver's side headrest. 52K, composite 11 ET photos of swabs taken from Ford F-150 driver's seatbelt. AAA, coming in as 53, a composite Google searches, bigger staff. 54A, a composite 7 ET photos from scene, shell casings 1. 54B, composite 7 ET photos from scene, shell casings 2. 54C, composite 7 ET photos from scene, shell casings 3. 54D, composite 7 ET photos from scene, tire zoomed out. 54E, composite 7 ET photos from scene, tire zoomed in. 54F, composite 7 ET photos from scene, tire fingerprints. Triple C, coming in as 55A through 55F. 55A, composite 6 pages of beaches pawn shop transactions. 55B, composite 6 pages of beaches pawn shop transactions. 55C, composite 6 pages of beaches pawn shop transactions. 55D, composite 6 pages of beaches pawn shop transactions. 55E, composite 6 pages of beaches pawn shop transactions. 55F, composite 6 pages of beaches pawn shop transactions. Triple D, 56A through 56C, composite 3 ET photos of Ford F-150 truck and house. 56B, composite 3 ET photos of Ford F-150 truck right side. 56C, composite 3 ET photos of Ford F-150 truck right rear.
All right, thank you. Is there anything else that we need to take up prior to bringing in the jury?
Just that, Your Honor, Mr. Dreiser and I had agreed to stipulation and admission of evidence prior to opening statements. I know the state is using very few, but a few slides of photographs, and I think Mr. Dreiser has a PowerPoint. I just want to let the court know that and make sure that that is all right with the court.
Absolutely.
Same.
Okay, thank you.
And for the court, Mr. Hill is doing our opening statement.
All right, thank you. Yes, and who's doing the opening for the state? All right, thank you. All right, Ms. Gordon. Officer Lynn, before she brings them in, just make sure that the lawyer's back in place, okay? I just want her to get them lined up, ready to come in. So hold the door until I say so. Are both PowerPoints loaded up and ready to go? I don't know how, it depends on how long, but it's true. You need a second, I can.
We will need a second, Your Honor.
Okay, I'll do that then. Hold. Are y'all ready? One moment. Ready? Mr. Dreiser. Let's bring in the jury. Thank you. All right, members of the jury, remain standing, okay? Give me just one moment. The gallery and the parties may be seated. Members of the jury, you were sworn in before we left at our last session. Does everyone still reaffirm their oath? All right, you may be seated. Good morning. All right, outside of your presence, we've been doing some work that hopefully will ensure that the trial will go smoothly. We've been working, that is both sides and the court have been working to make sure that we can get some housekeeping matters taken care of so that when we start the trial, it will occur more smoothly. You know that I like to talk to you all about schedule, so let me let you know what your morning is going to look like. This morning, this court is going to open the proceedings with the preliminary instructions. After I read those to you, the lawyers, if they wish, will give an opening statement. A note about, and a reminder, I know it's been some time since we've seen each other, that I am the judge of the law, and you all are the judges of fact. Our roles do not overlap in any way. However, this court's purpose is to guide you with the law. Once I decide what laws apply to the case, you will see that I will be reading to you quite a bit. I mentioned that because it's a little bit unnatural to have, someone read to you. So once I decide what laws apply, I read them to you. And so the preliminary instructions are meant to guide you through the trial process. They are meant to introduce you to the procedures that you will see throughout the entire trial. So the preliminary instructions, I'm going to ask that you listen to them. And at one point in time, I'm going to pause in just a moment to let you do some things with your notepad, okay? However, I'm going to fast forward to the end of the proceedings where this court will give you the final instructions on the law. Those final instructions will be both read to you and they will be published for you right on the screens in front of you so that you can follow along. The final instructions are more technical and you will have a copy of those instructions to help you during deliberations. And so I've confirmed with both sides, that is both the state of Florida and the defense in this case, that they are ready to proceed. So this court will open with the preliminary instructions. Members of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Mario Enrique Fernandez Saldana. This is a criminal case. The defendant has been charged with the crimes of murder in the first degree and solicitation to commit a capital felony. The definitions of those crimes will be explained to you later. You must decide this case based on the evidence presented and the law that I will give to you. Evidence consists of the sworn testimony of witnesses, exhibits admitted into evidence, and anything else that I tell you that you may consider as evidence. Your verdict must be based solely on the evidence or the lack of evidence and the law. The state's charging document, which is called an indictment, is not evidence, and it is not to be considered by you as any proof of the defendant's guilt. I will now explain the different roles that the court and the jury perform during the course of a trial. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against the defendant in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. During the trial, it may be necessary for me to confer with the attorneys outside of your hearing to discuss matters that require my consideration alone. It is impossible to predict when such conferences may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of this case. Please feel free to stand and stretch if you need to while I'm talking to the attorneys. You all have been provided a notepad and a pen for your use if you wish to take notes. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. But regardless of whether you choose to take notes, if you would please put your name on the first page of the notepad that's been provided. If you please do that now. All right, thank you. Any notes that you take during this trial will be for your personal use. And to ensure that your notes remain private, please do not write any notes on the first page of the notepad that has your name on it. If you wish, you can use all subsequent pages to write your notes. You will not be allowed to take your notes with you from the courtroom. During recesses, please turn your notepad over, and the bailiffs will ensure that no one will attempt to read your notes. Over the night's recesses, the bailiffs will take possession of your notes and then will return them to you when we reconvene. After the conclusion of the evidence and the arguments of the attorneys and the final instructions on the law by me, you will be allowed to use your notes during deliberations. When you have completed your deliberations, your notes will be destroyed. No one will ever read your notes. This is an important consideration if you do decide to take notes during this trial. Please do not get so involved in note-taking that you become distracted from the proceeding. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Members of the jury, I'm going to now reread and remind you of the communication rules that you've been instructed on previously. And you must follow these rules until you are discharged from your service as a juror. Jurors must decide this case, and that's without distraction and only on the evidence presented here in the courtroom. Jurors must not conduct any investigation on their own, and this means reading newspapers, watching television, or using a computer, cell phone, the internet, or electronic device, or any other means at all to get information related to this case or the people and places involved in this case. You may not visit the places mentioned during this trial or use the internet to look at maps or pictures to see any place discussed during this trial. You are also not permitted to communicate about this case, and that's with anyone, including your spouse, your family members, friends, neighbors, and even your fellow jurors. The communication with your fellow jurors about this case should only occur when the court instructs you to begin deliberations. During the trial, the court will take recesses and you will be permitted to separate and go about your personal affairs. It is important to remember that this prohibition on communicating about this case applies during these recesses, whether you're in the courthouse or elsewhere. If at any time you find yourself in a situation where others are discussing this case in your presence, please leave that situation at once and immediately report the matter to the bailiff, who will then advise me. You cannot have your cell phones or other electronic devices here in the courtroom while court is in session. However, you may use these devices during recesses, but you still must follow these communication rules. To ensure your privacy as a juror, please do not take photographs, video recordings, or audio recordings of your fellow jurors while deliberating. You must not communicate with anyone outside the jury room. The jury room has all the electronic equipment that you will need to view the evidence. The jury room does not have a phone or internet capabilities. I know I've explained it, but I'm going to say it one more time. What are the reasons for these rules? If you investigate, if you research, or you make inquiries on your own, I have no way to make sure that the information that you obtained is proper for this case. And the parties likewise would have no opportunity to dispute or challenge the accuracy of what you find. And this is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result. That would require this entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the party, the court, and the taxpayers. If you become aware of any violation of these rules at all, please notify court personnel of the violation. In conclusion, you should not form any definite or fixed opinion on the merits of this case until you've heard all the evidence, the arguments of the attorneys, and the law and the instructions on the law by me. Until that time, you should not discuss this case amongst yourselves. You must follow the communication rule. This case must be tried by you only on the evidence presented during this trial, in your presence, in the presence of the defendant, the attorneys, and me. Members of the jury, that concludes the preliminary instructions. I turn the case over for opening statements. State of Florida.
May it please the court.
Ms. Stifler.
Counsel. The Sanctuary neighborhood in Jacksonville Beach, Florida, is exactly what it sounds like. It's a small residential enclave of nice homes with golf carts and boats in the driveway. But on the night of February 16th, 2022, Sanctuary was anything but that for Jared Bridegan. Instead, Sanctuary Boulevard South was the site of his execution. Jared had just dropped off 2 children that he shared with his ex-wife, Shanna Gardner, at her home at Marsh Inlet, about 2.5 miles north of what would be the site of his death. His ex-wife, Miss Gardner, lived there with her new husband, this defendant, Mario Fernandez. Jared dropped his children off and was on his way home to Nocatee, where he lived with his new wife, Kirsten Bridegan, and their 2 daughters. One of his daughters, 2-year-old Bexley Bridegan, was in the car with him. Minutes after he left Miss Gardner's children safely at her home, he reached Sanctuary Boulevard South, where a tire was laying in the road. A dark residential road surrounded on either side by trees with 2 high curbs on each side, one way south, a tree line, and one way north. He put his vehicle in park, put on his flashers, and got out of his car to move the tire. A figure from the darkness stepped out with a firearm and fired 4 10-millimeter bullets, 2 of which went into the vehicle, the passenger compartment, inches from where 2-year-old Bexley Bridegan was strapped in her car seat. 2 of those bullets went into Jared Bridegan. He ended up face down on the pavement of that cold, dark road. He lay there, and Bexley Bridegan remained strapped in her car seat. A seat designed to keep her safe now held her unable to move for nearly 7 minutes until anybody arrived. Due to his injuries, Jared could not get up and he could not reach her. Every parent's worst nightmare. To die not knowing if any of those bullets had hit his daughter. To die not knowing if she was safe. The person who shot Jared disappeared into the night. There were no witnesses other than Bexley. Nothing. 7 minutes after those gunshots, vehicles started to back up behind Jared's stopped vehicle. 2 people, Shane Borgia and Janelle Cruz, happened to be passing through the area. They got out of their vehicle and walked up to Jared's car with its driver's door open and his flashers on. Shane saw the car, the flashers, and Jared laying face down on the asphalt. Thought it could be a car accident until he saw all the blood and until he saw Bexley in her car seat. He unbuckled her, pulled her out, took her to Janelle. Despite being only 2.5, Bexley was an articulate and intelligent child. Despite it being a warm night for February, she was shaking. She told Janelle, "Something happened to my daddy. I heard loud booms. My daddy's hurt. My daddy's on the ground." She asked, "Are the police going to help my daddy?" Well, police arrived, and unfortunately, they could give Jared no help. Shortly before 8 p.m. on February 16th, Jared Bridegan died face down on that asphalt at Sanctuary Boulevard. Not from a car accident, but from a premeditated murder. A targeted ambush, a planned tactical ambush with a tire in the road in a dark place where no one would see and no one would know and no one would trace it back to those responsible. For one purpose, to kill Jared Bridegan, a killer in the darkness who was picked, hired, solicited for that purpose. And then to disappear into the night. No trace he was ever there. No link to Jared other than being the last person he ever saw on earth. And no trail back to the people who planned and financed Jared's killing. The architects of Jared Bridegan's murder intended it to be the perfect crime. And it almost was. There were no witnesses, but there was an eye in the sky. A surveillance camera, 2 houses down, was able to capture a figure next to Jared's car and the last of the 4 gunshots. That camera captured this figure firing that last gunshot, then walking and then running from frame. Now, standing here in this courtroom 4.5 years later, it seems obvious, goes without saying, that this was an ambush, this was targeted. But that night, it was less so obvious. Officers from the Jacksonville Beach Police Department responded. They were young, they were inexperienced with homicides. Homicides generally don't happen in a neighborhood like Sanctuary, or for Jacksonville Beach for that matter, and certainly not a homicide of a man with his child in the car on a dark road. What you will hear is they began a years-long investigation. They used cutting-edge technology and old-fashioned, boots on the ground, knocking on doors police work. A man executed in front of his child by a ghost in the darkness. What was clear from that night, though, was that the manner and method of Jared's death was not consistent with a robbery. Jared's wedding ring, his Apple Watch, his phone, his debit cards were all unseen. Bexley was unharmed. That video, the audio of gunshots and the video of that person calmly walking and then running out of sight showed no dispute. There were no voices picked up. There was no indication of a road rage incident. And then there was that tire. The surveillance that I talked about showed that before Jared's death, minutes before, traffic had been passing unobstructed through that area, meaning that the killer placed that tire in the road seconds before Jared Bridegan got there. That tire was a trap. That road at Sanctuary, unlike other ones, with those two high curbs and the woods on either side, very dark, no street lights at that time, no cameras, no businesses, no houses in that immediate vicinity of that road. Feet away from the cut to J. Turner Butler. So dark. Putting a tire in the road that way would virtually guarantee that somebody would have to stop and move it out of the way, rather than risk driving up over those high curbs with those woods on either side. The tire was the trap to get him to stop, to get him to get out of the car, to leave him vulnerable and exposed. That tire was as much the murder weapon that killed Jared Bridegan as the firearm that fired those bullets. So the surveillance clip from police, the figure in the night, the audio of a pattern of gunshots, bang, 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 steady, consistent. All of it combined that night to let the police know what they were dealing with here was not random. This was intentional. This murder was personal. So the question that night for police, who in the world wanted Jared Bridegan dead? Who had the motive? Who would benefit from his death? Over their investigation for years, that answer, and the reason that you are all here in court today, Shanna Gardner, his ex-wife, and her new husband, this defendant, Mario Fernandez. As Mr. Mizrahi told you last week during jury selection, the state of Florida has charged Mario Fernandez with 2 crimes: first-degree murder, premeditated murder, and solicitation to commit a capital offense. Now, the burden is on the state of Florida to prove these charges beyond a reasonable doubt. We welcome that burden. We will do that over the next week and a half by presenting evidence in the forms of exhibits and witness testimony. You will have the law as instructed by the court. You have one more thing, equally as important as though two, that you bring with you into this room and back into that deliberation room. That is your common sense. What will become apparent to you very quickly was the same fact that became apparent to those investigators years ago. No one in the world truly wanted Jared Bridegan dead. No one in the world truly benefited from his death. No one in the world truly had motive to kill him, except for Gardner and Fernandez. A little background. Shanna Gardner and Jared Bridegan were married very young after a quick courtship. They were both members of the Church of Jesus Christ of Latter-day Saints, which you all may know as the Mormon Church. They were married, they had twin children, they moved from Utah, various places in the country, and ended up in Jacksonville, Florida, because one of their children had a heart condition and needed to live at sea level. Jared was very religious. He wanted to raise the children in the church. At some point during their marriage, Ms. Gardner began to question her religion. She wanted to leave the church. She did not want to raise her children the way that she was raised in the church. They had strife. They got divorced. And in some time had passed, the acrimony of that divorce never did. It remained very bitter between the two of them, despite the fact that they both later remarried. Jared Bridegan remarried Kirsten Bridegan in 2017, and Shanna Gardner remarried this defendant, Mario Fernandez, in 2018. Mario Fernandez and Shanna Gardner met at a gym. She was doing workout classes and training. He was the maintenance man. He grew up in Jacksonville. She grew up in a very, very wealthy family in Utah. They had a very short courtship, and then they got married. Their marriage was not one necessarily of true love, but of convenience. It was a deal. His words, not mine. You'll hear that he told police that he married Ms. Gardner to help her with the kids, to help her with the Jared situation, and that they sealed the deal when he talked about their marriage. The two couples co-parented. They did not do so amicably. You will see the court filings. You will see they were in and out of court for years. Big issues, medical treatment, where the kids went to school, small issues, who's going to pay for this, who's going to pay for that. They fought over everything. Can she dye her hair? Who pays for the oxygen tank? They got to the point where they would only communicate, the four of them, in writing, separate parent-teacher conferences, separate doctor's appointments. It was nasty. It was petty. It was not good on both sides. But Shanna Gardner complained about the custody agreement incessantly. She wanted full custody, particularly because Jared was bringing the children, especially their young daughter, into the church that she now did not want to be a part of, that she now despised. The defendant himself told police after Jared's death that they were seeking full custody, that they wanted full custody, that they would have even been happier with more custody, 60-40 as opposed to the 50-50. The defendant, after Jared Bridegan's death, told police that the kids were better off without him. And the money. Ms. Gardner was from a very wealthy family, and her parents, in order to protect her assets, set up a trust fund for her, the Shanna Gardner Irrevocable Trust Fund. And this defendant was the trustee. She had in the trust a clause that stated that when she had no more legal entanglements with Jared Bridegan, that she could elect to serve as a trustee of her own trust and gain access and control over her money. Before Jared's death, you may hear evidence that Gardner and Fernandez, this defendant, were planning to separate and divorce. He would no longer be trustee over her finances and live in the nice house at Marsh Inlet that her parents bought for them, and drive his Toyota Tundra that was purchased for him during the marriage. They had also decided to separate. They were not in love. This marriage of convenience had run its course. And then Jared Bridegan was murdered. And Mario Fernandez and Shanna Gardner remain legally married to this day. 4 months after the death, the defendant remained the trustee on her trust. A week after Jared Bridegan's death, the defendant transferred $50,000 from Shanna Gardner's trust into his own personal checking account. For months after Jared Bridegan's death, they continued to live together until they separated. He gained half the proceeds of the sale of their home at Marsh Inlet that her parents had purchased. He sold the Tesla that they had during the marriage. He sold the Toyota Tundra they had during the marriage, and he continued to move money around. Ms. Gardner got what she wanted: full control over her children and the freedom to move out of Jacksonville, Florida. 6 months after Jared's death, she left the state of Florida without the defendant, her legal husband, and moved to Washington State with her 2 children into a home purchased by her parents through an LLC. Mr. Fernandez eventually moved to Orlando. The facts I just told you are undisputed. You're going to see bank records, court.
I'll sustain it. You can rephrase.
The facts that I just described to you come from the records themselves: bank records, the court filings, interview of the defendant, the witnesses who will take the stand. Clearly, they had motive. They benefited greatly from Jared's death. And the detectives with the Jacksonville Beach Police Department knew this. They heard this. They conducted hundreds of interviews. They pulled bank records. They pulled phone records. They knew that these people had a motive. And although they were suspicious, they did not rush their investigation. They looked at every possible lead, which were few and far between, given the nature, the method, the manner of Jared's death. They also learned that other than Gardner and the defendant, there were no other true individuals with actual motive to have Jared dead.
Grounds. Okay. that better? Okay. All right, you may proceed.
Thank you, Your Honor. You will hear that the Jacksonville Beach Police conducted an investigation which uncovered that there were no other suspects with a true motivation to kill Jared Bridegan. They interviewed Jared's widow, Kirsten Bridegan. They spoke to his family members. They spoke to his friends. They spoke to his coworkers. They spoke to anybody in the past that had any type of argument or dispute with him. They followed every lead they possibly could. They went to his home. They got his work laptop, his hard drive, his personal laptop, his phone. They extracted them. They downloaded them. His widow, Mrs. Bridegan, provided police with passwords and access. She let them into her home and showed them where her husband had kept his firearms. What they learned about Jared Bridegan through his digital life and through these interviews with those that knew him best was that he was a risk-averse person. He worked from home. He had a very small circle, few friends, family, few hobbies. There was no evidence uncovered through their search of his devices or through interviews that he was in any kind of gambling debt, any significant financial debt. He had no criminal record, no history of arrests. There were no drugs in his talk screen, no indication that he was buying or selling drugs, no indication from his devices or for interviews that he was having an affair, that he had an ongoing long-term dispute with anybody, save them. He didn't go out partying. He didn't travel. He lived in Nocatee. He worked from home. And he led a quiet life. He attended church every Sunday and was devoutly Mormon. So not only did the police learn of the motive of Ms. Gardner and Mr. Fernandez, the defendant, they also learned through investigation and through following leads and talking to everybody and anybody that could potentially have any information, that there appeared to be nobody else with a motive to kill Jared Bridegan. Like I said, they didn't jump to conclusions. They pulled phone records and financial records for his widow, for family members. They tried to use cutting-edge investigative techniques, some things you'll learn about during this trial, like tower dumps and geofence. They cobbled together what surveillance they had. Nothing turned up a significant lead that sent them anywhere. They went door to door to door through the miles of homes in Jacksonville Beach, knocking, looking for eyewitnesses, looking for surveillance video. Nobody saw the murder. Nobody could give them a suspect description. They had nothing but a shadowy figure on the screen. They had the manner of death, that this was personal and targeted. And they had some other things that the killer had left behind. Very little. What they had was the tire in the road. The tire had a rim on it that they were able to identify through OPM records, manufacturer records, that it belonged to a Ford F-150. And when they learned that, they started looking on surveillance. They found Jared's vehicle, the black VW Atlas, which is what he drove, and they saw that minutes and seconds before he reached Sanctuary, where he was killed, that there seemed to be a vehicle in frame with his vehicle. And that vehicle was a blue Ford F-150 with a tan stripe along the running board. So they expanded their surveillance search. They found more video of that particular vehicle. You will see a compilation of clips of that truck that they identified through hundreds of hours of video that they poured over. You will see that that blue truck, F-150, arrived to Jacksonville Beach around 5:45 p.m. on Beach Boulevard that it drove down through the back residential winding roads that Jared would have taken from the defendant's home at Marsh Inlet to Sanctuary where he was killed before the homicide. That it drove down Sanctuary Boulevard South, that same eye in the sky that caught that figure, miraculously also was triggered by someone taking out their trash. And it caught a blue Ford F-150 with a tan running board driving down Sanctuary an hour before the murder, slowing down and almost appearing to stop at the very site where Jared would be killed an hour later. It caught that car coming back up, driving around, and then pulling in to an apartment complex cut, an area called Pablo Hamlet at Cheddar, a street north of the homicide scene in Jacksonville Beach, a street where this blue truck that was seen slowing at the homicide scene and then driving away from the homicide scene shortly after Jared was killed, waited for a period of about 20 minutes before Jared's death. And this street, Cheddar, this Pablo Hamlet area, isn't just anywhere in Jacksonville Beach. It is exactly one street over and directly behind that house in Marsh Inlet where Shanna Gardner and Mario Fernandez lived. Detectives followed that surveillance of the blue truck. They saw it in front of Jared seconds before his death. It appeared to be moving fast, as if trying to put distance between itself and Jared's vehicle, as if trying to create time, perhaps to lay down a tire and set a trap. That blue vehicle was seen driving north away from the homicide scene after the gunshots. That blue truck was seen before the homicide on surveillance with what appeared to be an object in its bed, consistent with a tire. At 6:41 p.m. on Grande Boulevard, a camera picked up that truck, the tire in the back. At 7:54 minutes after the homicide, that same camera at Grande picked up that truck, this time going north, away from the homicide scene, and that tire was not in the bed of the truck anymore. The detectives felt like this was the first real lead. This vehicle, it was an older model. It was a blue truck with a running stripe that was tan on the bottom. It was unique enough that they could move on it. They could put it out there. They released a photo to the public. They begged for tips. They asked for people to call in. Has anybody seen this truck? Because the surveillance was too grainy to make out a license plate or even the state of the tag. And Jacksonville Beach at this time did not have what we call license plate readers. All they had was a make, a model, and a general appearance. But no legitimate leads came in. And the trail on the truck for some time went cold. The other piece of evidence that the killer left behind was the expelled cartridge casings from the firearm used to kill Jared Bridegan. When you fire a semi-automatic handgun, the cartridge, or what we in layman's terms usually say bullet or ammo, the projectile is expelled and the cartridge, or shell casing, as some people might call it, is ejected. In this case, the killer took the gun with him when he fled, but he did not pick up the shell casings. So those 4 shots, 4 10-millimeter cartridge casings or shell casings or shells were left behind at the homicide scene. And detectives had something to work with there, because although there are 10 millimeters manufactured and distributed, it is not the most common caliber firearm. It's not like a 9 or a 40. It gave them something to look into. And not only was it a 10 millimeter firearm used and 10 millimeter ammunition, an expert from the Florida Department of Law Enforcement will tell you that they are able to determine it most likely came from a Glock 10 millimeter firearm. Because when it's shot, it leaves a certain pattern from the firing pin, consistent with a Glock, consistent with their proprietary design. And not only was it most likely a Glock 10 millimeter, it was probably an older model Glock 10 millimeter. So the detectives tracked down every FFL sale of a 10mm firearm in the months preceding the homicide. They pulled pawn records for 10mm pawned, and they worked with the Jacksonville Sheriff's Office NIBIN unit, a National Integrated Ballistics Information Network, to try to track down any 10mm that they could. And they followed up on it. They figured out who purchased 10mm from FFLs. They figured out who pawned 10mm. They sent officers out to talk to these people, to look at their names, to run their records, to see if there was any connection to any of them in Jared Bridegan through his phone records, bank statements, or device downloads, through interviews with his friends and family, and there were none. And lastly, they had the time and place of Jared's death as a clue. Although not physical evidence, that gave them information as well. Because the path that Jared Bridegan took from Marsh Inlet to Sanctuary is a windy path through a residential area. It's a cut through. Unless you live in the neighborhood or are familiar with it, most likely you're not driving that route. And they knew that the tire had not been in the road until moments before Jared's death. So they knew the killer had to have known, one, that Jared Bridegan would be in Jacksonville Beach that night, even though he lived and worked in Nocatee. Two, that he would be driving a black VW Atlas. And three, that he would be going down Sanctuary at that exact moment, the right time for the killer to execute his plan and execute Jared. And there were not that many people in the world that knew that Jared Bridegan would be in Jacksonville Beach that Wednesday night, February 16th, 2022, at approximately those times. But some people did, including Shanna Gardner and the defendant, Mario Fernandez. Because part of their custody arrangement for this 50-50 parental time sharing was that on the week that the parents did not have the twins, they would get a date night with them. So on the weeks where the twins were at Gardner and Fernandez's, Jared Bridegan would come to Jacksonville Beach, pick up the twins, and take them out to dinner. And they called it date night. And it was always Wednesday night, every other Wednesday night. And it was always around the same time, between 6:30 and 8 p.m. So the killer had to have known about date night, or that Jared would be there that night, because February 16th, 2022 was a Wednesday night and was a date night. That's why he was there, picking up and dropping off the children. And the killer had to have known that Jared would be in his black VW Atlas. And in order to kill Jared Bridegan and leave no witnesses behind, the killer would have known that Jared would be with his daughter Bexley, but that his wife, Kirsten Bridegan, would not. That she had given birth to their second daughter 6 months ago and had not been going on date night for the past couple months. So the killer had a blue truck, a tire, a 10mm firearm, and information about Jared Bridegan's whereabouts in order to successfully carry out the plan to kill him. And the detectives followed these leads as best they could, and the trail ran cold. And they kept coming back to the names Shanna Gardner and Mario Fernandez as they eliminated other possibilities. They continued to follow every lead. And months passed, and they decided to start expanding their interviews, talk to everybody and anybody, no matter how insignificant they seem, to see if they have any information. When doing this in July of 2022, a few months after Jared's death, and a month or two after the trail had gone cold, they ended up at a residence in the Jacksonville's northwest side, 5239 Potomac Avenue, just near Edgewood and Kings Road, a little north of the Paxton area, if you're familiar. And it's about 40 minutes from Jacksonville Beach. 5239 Potomac is a home owned by this defendant, Mario Fernandez. He was using it as a rental property, and it was managed by an LLC called First Choice Home Rentals, an LLC that was incorporated by Mario Fernandez and Shanna Gardner. They were joint business partners. This house is not like the Marsh Inlet house or the houses in Sanctuary. You'll see photographs of the house, of the state of its disrepair. Rent there was not expensive. In July of 2022, detectives went to that home because they knew Mr. Fernandez was a landlord and was renting the property, and they spoke to the tenants there. A man named Jeremy Ordway and another man arrived while they were there, a former tenant named Henry Tenen. And while detectives were speaking to Mr. Ordway and Henry Tenen, they noticed against the side of the house an old tire. It had been put out for garbage collection, and by some stroke of luck, they happened to be there that day and happened to see it before it was taken to the dump. They took that tire, collected it, brought it back to the Jacksonville Beach Police Department, and compared it to the tire left at the crime scene, the tire used as a trap, the tire used to murder Jared Bridegan. And they realized it was the same make and model. It had the same DOT number, meaning it was manufactured by Michelin in the same factory the same week as the tire from the crime scene. That was the first real lead that blew the case open. Here's this tire leaning against the house that this defendant owns. And they realized very quickly that the man that arrived at the house, Henry Tenen, owned a blue and tan two-toned older model Ford F-150 Lariat that he had inherited from his father. Who is Henry Tenen? Oh, I should go with the picture. Henry Tenen is a man in his now late 60s and mid 60s around the time of this homicide. Henry Tenen has a 12th grade education. He has limited family in Georgia. He's a convicted felon. He is a day laborer. He worked for a pallet company. Pallets are those big wooden pallets they use to stack equipment, and his job was to take old pallets and break them down into pieces. It's heavy manual labor, and he got paid by the piece, not by the hour, not a salary. He got paid by the piece. Detectives pulled his bank records. His bank account was frequently overdrawn. He was back due on child support. His wages at the pallet company where he worked were being garnished. Through the majority of 2022, he was essentially homeless. He was sleeping on couches. He was sleeping on a couch at 5239 Potomac Avenue because his friend, the tenant, Mr. Ordway, let him. He was living, as they say in Potomac, pillow to post. He had been a tenant at one point at the Potomac Avenue home, but had been evicted in early 2022 when Mr. Ordway began leasing the property in January of 2022. Henry Tenen's only connection to Jared Bridegan is this defendant, Mario Fernandez. Detectives began looking into him. They were able to find his tag registration. They were able to find that he owned a truck similar to the one they saw on surveillance video, similar to the murder truck. So they arrested him in August of 2022 for driving charges, driving on a suspended license. To further their investigation, they were able to obtain a phone off of his person. They were able to get a set of car keys from his pocket that belonged to a Ford F-150, even though he was driving a Crown Vic, and even though there was no sighting or sign of the truck that he had inherited from his father. They pulled his bank records from his phone. They were able to obtain a phone number, an email address, and they were able to get Google location data, something you'll hear about during this trial. something that existed and was new at the time and now is no longer kept for law enforcement purposes by Google. A moment in time, detectives were able to get this information. And what it told them was that Henry Tennant's phone number, email address, linked to his Android phone were in Jacksonville Beach the night of February 16th, 2022. And not just in Jacksonville Beach, a block or two away from the homicide scene, minutes after Jared Bridegan was killed. From that location data, detectives were able to go back to that surveillance they collected, and they were able to identify a black male on camera walking from the homicide scene and walking throughout Jacksonville Beach after the murder. And in that video, they were able to determine that the person had a jacket and a pair of boots that looked very, very, very similar to a jacket and a pair of boots that they collected from 5239 Potomac Avenue belonging to Henry Tennant. They eventually found his truck in the yard of a family friend. Henry Tennant's vehicle. A vehicle that looked very similar to this vehicle before the homicide, driving on Grande Boulevard with a tire in the back bed, leaving the homicide scene after the murder with no tire. Most importantly, they got his DNA. His DNA came back on the steering wheel of this blue vehicle. It came back on those keys that were in his pocket for a Ford F-150, keys that unlocked this vehicle. And Henry Tennant's DNA came back on a swab of the inner rim of that tire at Sanctuary Boulevard South that was put in the road to trap and kill Jared Bridegan. Detectives realized Henry Tennant was the shooter. Although they searched and searched, they found no link between Jared Bridegan, Kirsten Bridegan, the Bridegan family, and Henry Tennant. They found no motive for Henry Tennant to have wanted Jared Bridegan dead. The killer was a stranger to Jared Bridegan. The murder was personal. And what you will see this week is the link between the two is this defendant, Mario Fernandez. That link between those leads, between the tire to the truck to the defendant, between the manner of the death, the time and the place and the timing, and this defendant. The investigation the detectives did started with that evidence, and it led to Henry Tennant, and it led right back to Mario Fernandez. And that's a common theme you'll see this week. Everything they investigated that had potential to give actual evidentiary value led from Mario Fernandez to information. And the more they investigated that information, the more they looked into Henry Tennant, the more they looked into the tire, it led right back to Mario Fernandez. You'll see another connection. As they realized that Henry Tennant was involved in this murder, they started to take a harder look at the other associates of Mario Fernandez. Just as the killer was linked to Mario through that truck and tire, you will hear about a link between that 10mm Glock firearm and Mario Fernandez. You will hear about Mario Fernandez's friendship with a man named John Biggerstaff. John Biggerstaff and Mario Fernandez have known each other for decades. He went to high school with Mr. Biggerstaff's children, and they maintained over the years an acquaintanceship and a friendship off and on. They would work out, hang out. You will also hear that John Biggerstaff was a former Navy cryptologist and a former JSO reserve officer until he was federally prosecuted for a felony. He and Mr. Fernandez were in close contact in 2022, leading up to the homicide. You'll hear that they spent time together in Mr. Biggerstaff's home in his garage, talking about the custody battle, sharing beers, venting. You will hear that John Biggerstaff is the person that Mario Fernandez called after hearing about the murder of Jared Bridegan. One of his first contacts, one of his first calls was to John Biggerstaff in the early morning hours of February 17th, after police let them know Jared Bridegan had been killed. you will hear that Mario Fernandez was at John Biggerstaff's house the night before the murder, February 15th into the early morning hours of February 16th. And you will hear that Mario Fernandez spent February 17th, the day after Jared's murder, with John Biggerstaff. And this is significant because when John Biggerstaff became a convicted felon and was fired from JSO, he had to surrender his firearms, and he surrendered them to his son, Juan Biggerstaff. One of the firearms that he surrendered was a Glock older model 10mm firearm. So detectives investigated. They spoke to Mr. Biggerstaff. They spoke to his son, Juan. They tracked down purchase records. They were trying to find this firearm. You will hear from the Florida Department of Law Enforcement expert that if you have shell casings left behind on a scene and you have a firearm, you can test fire it, you can compare those casings, and you can scientifically determine if casings on a scene were fired by a certain gun. So the police obviously wanted to obtain Mr. Biggerstaff's Glock 10mm to see if it was the weapon used to kill Jared Bridegan or not. And they are unable to do that to this day because Mr. John Biggerstaff and his son, Juan Biggerstaff, have forgotten where this firearm is. They just don't know. They can't produce it. They can't tell anyone where it is. We have been unable to find it and to test it to see whether or not that was the firearm used to kill Jared Bridegan. A gun we don't have because the defendant's close friend that he hung out with the day before the murder and the day after the murder can't produce his Glock 10mm firearm. And like Henry Tenon, John Biggerstaff has no connection to Jared Bridegan or to Kirsten Bridegan or to the Bridegan family. Another piece of evidence that we found by starting with Mario Fernandez that led right back to him. Another link between two people who are strangers to Jared Bridegan and this defendant. These links, or coincidences as they might be called by defense during this case, are numerous. Jared had no connection to Henry Tenon, but someone had to tell him what vehicle he was in. Henry Tenon has no connection to Sanctuary neighborhood, but this route was specific. This ambush was pre-planned, given that evidence of that truck driving it before the murder. Someone had to have shown him where to go. Henry Tenon would not have known about date night unless someone told him. And Henry Tenon happened to kill Jared Bridegan with a Glock 10mm firearm, a relatively unusual firearm that someone had to give him. Henry Tenon, a tenant of Mario Fernandez, happened to kill the one person standing between this defendant and remaining in his marriage and profiting from that marriage to Shanna Gardner, and standing between Ms. Gardner and her ability to control her own money, control her freedom, and control her children. Those are the coincidences, as they might call them, you will hear about in the next 2 weeks. And the defendant and Ms. Gardner profited from the death of Jared Bridegan, as did Henry Tenon. You will also hear evidence that when they recovered Henry Tenon's truck, inside the truck were 3 check stubs, still together with numerical markings. And the police were able to go into Henry Tenon's bank records, find those check numbers, and see that Henry Tenon, in March and April of 2022, weeks after Jared's death, deposited 3 checks written by Mario Fernandez, the defendant. He deposited a $2,000 check with a subject line landscaping. He deposited a $3,000 check with the subject line keeping up with the roof. And he deposited a $5,000 check written by this defendant to the shooter that said, Kickstarter, good luck, exclamation point, exclamation point. Well, you'll see photos of the house at Potomac. You'll see its roof. You'll see its landscaping. You'll see the state of the home. You'll see Mr. Tennant's bank records and the fact that he was frequently overdrawn on his accounts, that he's a day laborer whose wages are being garnished by the government for back due child support. You will not hear any evidence from the downloads of Henry Tennant's phones or Google accounts that he ever had a Kickstarter. You will see very quickly that there are no way these are legitimate payments. You will have Mr. Fernandez's Google download, which contains his business dealings with First Choice Home Rentals as it relates to 5239 Potomac. And you'll see the difference between the legitimate expenditures he's giving to LLCs and air conditioning companies with invoices and estimates and scheduled times and emails versus these checks that just magically appeared out of nowhere for $10,000 to a man who earns $15,000 a year breaking down pallets. These checks were a way to hide money for a murder hidden in plain sight to make it look legitimate, with the hope that Henry Tennant would never be identified and no one would ever look that deep. Nobody during this trial is going to be able to take the stand and tell you about the conversations between Henry Tennant and Mario Fernandez regarding this murder. Henry Tennant has been charged. He will not be testifying as a witness, nor will Ms. Gardner. And you will hear evidence from phone records that Henry Tennant, despite not being a tenant of Mr. Fernandez past January of 2022, had multiple text messages and phone calls with the defendant in February and March of 2022 when he wasn't a tenant. Multiple phone calls and texts. I'm talking 70 text messages and calls in February 2022. You will hear that none of those text messages, the content, the call logs, exist on Henry Tennant's phones or devices. Henry Tennant deleted his contact with this defendant, Mario Fernandez. You will also hear that shortly after Henry Tennant was arrested in August 2022 on those driving on a suspended license charges unrelated to the murder, that Mario Fernandez, this defendant, factory reset, wiped his cell phone. Not just deleted. You'll hear from a forensic expert what it means to wipe your phone. What you lose, all the apps, all the passwords, financial records, banking records, every photograph someone has ever taken on their phone, gone, wiped. After his tenant, ex-tenant, is arrested on unrelated charges. We will also hear from his Google return that Mr. Fernandez deleted Henry Tennant as a contact in his Google Cloud, that he deleted over 6,000 records from his Google account. This is what we call consciousness of guilt. It's evidence you can consider this week as you evaluate what the state has presented. But you will not hear someone come in and say, Mario Fernandez paid me to kill Henry Tennant. Two people can keep a secret if one of them's dead, and for purposes of this trial, Henry Tennant is dead to you. He is not on trial. Shanna Gardner is not on trial. But the evidence of their consciousness of guilt is evidence of this defendant's guilt. We can't say where Mario Fernandez was during the time of the homicide. We know from surveillance, and you will see on the surveillance, that Henry Tennant is on foot for hours in Jacksonville Beach after the murder, about an hour and a half, trying to get out of Jacksonville Beach. You will also see surveillance that the blue truck with that tire in the back that left the homicide scene without that tire is separated from Henry Tennant, which means two people were there that night. One driving the truck, one person, Henry Tennant, murdering Jared Bridegan. Mario Fernandez's cell phone has the ability to tell us where he is through cell site location, your tower. And you'll hear a lot of evidence this trial about it from a lot of experts. But what you will hear is that Mario Fernandez has no cellular data or location data for the time of the murder. And again, you may hear argument of coincidences and network connectivity. But there's data before the murder, there's data after the murder, and there is no data during the murder. And because Mario Fernandez wiped his cell phone, the expert who would have been able to go in and look at his phone and say it was on airplane mode, it was off, it was on, it was at home using Wi-Fi, does not have that information to tell you that definitively. There's no DNA putting Mario Fernandez at the crime scene. There are no eyewitnesses. There's no video footage that captures the individuals or individual in the truck clearly enough to make them out. These things are all true. The phone at home, lack of DNA, no eyewitnesses. But it cannot change the fact that there is no connection between the shooter and Bridegan other than this defendant. It cannot change the fact that this defendant paid a man $10,000 for work that didn't happen and a Kickstarter that doesn't exist. You will also hear about some activity on the defendant's phone and Mr. Tennant's phone before the murder, about a trip that Tennant's phone took to St. Johns County to Nocatee, to the street where Jared Bridegan lives, 2 weeks before the homicide. A trip in a blue two-tone truck from Potomac to Jared Bridegan's house, to the crime scene and back to Potomac. A trip that Henry Tennant took while Mario Fernandez's phone was at the house at Potomac Avenue, not being used, stationary in one cell tower coverage area. No link between Henry Tennant and Jared Bridegan other than this defendant. I started my opening today describing the final moments of Jared Bridegan's life and the final moments that Bexley Bridegan had with her father as she witnessed him dying. I began that way to remind you of why we are here. Mr. Dreiser talked at jury selection about this case and media attention and the popularity of verdicts. A trial is about the state's ability to prove a charge beyond a reasonable doubt with evidence, not emotion, with facts, not feelings. But this is not a true crime podcast. This is not a TV show. This is real life. And the reason I started that way is so that does not get lost on you this week. That a man was wiped off the face of the earth in front of his daughter, and he died in a terrible way. I don't say this to inflame you. I say this so you remember why we are here. Our job is to prove the case beyond a reasonable doubt. Defense job is to defend their client. Your job is to return a verdict consistent with the law and the evidence. You will be answering those two questions Mr. Mizrahi brought up. Was a crime committed? Did the defendant do it? Did Mario Fernandez have the intent that Jared Bridegan be killed? And did he incite, cause, encourage, assist, hire, or solicit him to do that? Was he a principal to the death of Jared Bridegan? That is your question to answer with the evidence, the law, and your common sense. We are confident at the conclusion of this trial, your verdict will be consistent with the evidence and the law. We're confident that you will return a verdict of guilty as charged.
Thank you, Ms. Stifler. Members of the jury, we're going to take a brief recess. We will return back in session at 11 a.m. If you leave your notepads on your chair, please. The defense will now present their opening statement to you. The court reminds you that this gives the attorneys a chance to tell you what evidence that they believe will be presented during the trial, and what they say is not evidence and you're not to consider it as such. You may proceed, Mr. Hill.
Thank you, Your Honor. Please, the court. Jared Bridegan was murdered. Henry Tinnen murdered Jared Bridegan. Let me say that one more time. Jared Bridegan was murdered. And he was murdered by Henry Tinnen. There will be no dispute to those facts, no doubt. Mario Fernandez had no desire to murder Jared Bridegan. Mario Fernandez had no motive to murder Jared Bridegan. Mario Fernandez did not benefit from the murder of Jared Bridegan. Simply put, ladies and gentlemen, Mario Fernandez had no involvement in the murder of Jared Bridegan. That is what we believe the evidence will show. I'm going to take a moment to walk you through the law, the elements the state of Florida must prove beyond a reasonable doubt, a timeline with details of what we anticipate the facts will show, and why at the conclusion of this case, we're confident in asking you to return a verdict of not guilty. Ladies and gentlemen, the first charge in the indictment, murder in the first degree. As to count one, to prove the crime of first degree premeditated murder, the state must prove the following three elements, but actually they will only have to prove two. Element one, Jared Bridegan is dead. There is no dispute and no doubt to that element. The death was caused by the criminal act of Mario Enrique Fernandez Saldana. We anticipate there will be no evidence to support that whatsoever. Henry Tinnen murdered Jared Bridegan. Element three, there was a premeditated killing of Jared Bridegan. The evidence will show that Henry Tinnen had a premeditated killing of Jared Bridegan. The state mentioned, they said Henry Tinnen is the shooter. There will be no dispute to that fact. So they will seek to prove this case by claiming that Mr. Fernandez is a principal to first-degree murder. That instruction that the court will provide you is that if Mario Enrique Fernandez Saldana helped Henry Tinnen commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did, if the state proved beyond a reasonable doubt the following two elements. Number one, that Mario Fernandez intended Jared Bridegan to be murdered. And number two, that Mario Fernandez did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. Ladies and gentlemen, you heard Ms. Stifler. You will never hear a witness in a witness stand, see a text message or email, any communication between Mario Fernandez and Henry Tinnen intending that this crime be committed, inciting, causing, encouraging, assisting, or advising Henry Tinnen or any other person to commit the crime of murdering Jared Bridegan. Second charge, criminal solicitation to commit a capital felony, to wit, first-degree murder. In essence, to get to the first charge, you have to go through the second charge. As to count two, to prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Mario Enrique Fernandez Saldana solicited Henry Tennant to commit an offense prohibited by law, to wit, first-degree murder. Solicit means to ask earnestly or to try to induce another person, Henry Tennant, to engage in specific conduct. And number two, that during the solicitation, that Mario Enrique Fernandez Saldana commanded, encouraged, hired, or requested Henry Tennant to engage in specific conduct which would constitute the commission of first-degree murder or an attempt to commit first-degree murder. Ladies and gentlemen, that's the evidence the state has to put forth to you. They have to prove each of those elements, just like Mr. Dreiser said in jury selection when he gave a hypothetical about the links in a chain. And if none of those links are actually established, then the whole chain falls apart. That's what we believe the evidence will fail to show, are those links in the chain. Now, Ms. Stifler started this case, and she ended her opening statement with her statements of why we are here. We're here because a man was murdered by Henry Tennant with his child in the car. There's no doubt about that, and it's terrible. But I give credit to Ms. Stifler. She was correct. When you retire to that deliberation room, you have to leave a lot of your own human emotions here in this courtroom. The judge will provide an instruction, rules for deliberation. These are important. Asking you to do something that's not natural. But I want to touch on a couple of those. I think it'll aid in the process of the next 2 weeks. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses, as seen in the forms of exhibits and evidence in the instructions that the court will provide. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions that the court will provide you. What that means is you will be angry. You will have sympathy. You will feel sorry. There are victims on both sides of this courtroom, outside of this courtroom, around the country, quite frankly, around the world. Like when you retire to that deliberation room, you cannot allow the sympathy, sorry, and anger to influence your decision. Now, ladies and gentlemen, no need to read this slide. This is just an illustration that there is a lot of history between these people. And it starts April of 2010. Shanna Gardner and Jared Bridegan are married. 2 years later, they have twins. You've heard that one of those has a medical condition that'll likely come into evidence throughout the next week and a half, 2 weeks. And then in February of 2015, Shanna Gardner files for divorce in St. Johns County, where they resided at the time, and a number of months later, they were divorced. The state made a point to tell you that the evidence is going to suggest that this was a nasty divorce, nasty custody battle. We believe the evidence will show you the opposite, that they resolved their divorce by what's called a consent final judgment. For those of you lucky enough not to have gone through that process, that means that they reached an agreement by consent of both parties, including their custody. In Florida, they call it time sharing, that it was equal on both sides. In 2017, Jared Bridegan marries Kirsten Bridegan. The state said that there was short courtships. You'll see that that is somewhat of a theme, short courtships and fast marriages. That doesn't mean that they're not valid marriages. The state would want you to believe that the evidence is going to suggest that Mario Fernandez and Shanna Gardner had a marriage of convenience. Sometimes marriage is convenient, and you'll see that Mario Fernandez will be a good stepfather, and that he'll do an equal role. That's what the evidence will show. But once these parties were married, now with two separate households co-parenting these twins. You're going to hear it wasn't always perfect, and the state was correct. You can take your common sense back there. Two parties have divorced. They're now shifting two children back and forth. Would they have arguments? Certainly. Would they argue over school choice, medical devices, and child support, hair colors? Yes. But you're going to hear that once there were now new spouses, there's going to be a family text, a text chain. You'll likely hear there were thousands of messages between Kirsten Bridegan, Jared Bridegan, Mario Fernandez, and Shanna Gardner. You will not hear anyone take the stand, say there were threats of violence, any types of suggestions of violence. They will say both sides at times would say things they maybe regret, cheap shots at one another, little digs, but no violence. There will not be a witness that will take the witness stand. You'll see no evidence that law enforcement was ever called. The Department of Children and Families ever got involved, or that any of them went down to the second floor to domestic relations and filed for an injunction or what you may think of as a restraining order. They weren't perfect, but they made it work. They even had a consent order right up to October of 2021. Now, the state in count 2 of their indictment provides a date range starting November 1st of 2021, leading up to the date of the homicide, February 16th, 2022. There will be no evidence that you will see. We anticipate no evidence whatsoever of anything suggesting that Mario Fernandez has any involvement in the murder of Jared Bridegan. You will see nothing in December giving any suggestion that Mario Fernandez hired, solicited, or had any involvement, desire, or intent for Jared Bridegan to be murdered. I anticipate the state is going to call an FBI agent named Bobby Blythe. And he's going to testify to forensic data. He's a cast agent, meaning he will take cell phone data and he will try to plot maps with arches and graphs to try to give an idea of where a device is. He will not be able to tell you this is where a person is, but this is where a device connected to that person is. And he'll tell you that a device that's associated with Henry Tenen travels to Jacksonville Beach on January 5th of 2022. You'll likely see a map with little plots, much like you would using your own navigation apps. It'll show him in Jacksonville Beach area. It'll show him travel down by the Jacksonville Beach golf course. He will not go all the way down to where the homicide scene is. He'll briefly go down the road that Shanna Gardner and Mario Fernandez live on, but he will not testify that the device ever stopped at that location. And certainly there will be no evidence, no witness, no data that will be presented to say that Henry Tenen, the murderer, had any communication or connection with Mario Fernandez or Shanna Gardner. Now, Shanna Gardner's name was mentioned at least a dozen times. She's not on trial here. Mario Fernandez is. And the indictment alleges solicitation of Henry Tenen, not Shanna Gardner. You have to be focused on Mario Fernandez. John Biggerstaff. The state actually did a really good job of explaining, kind of stole my thunder, of who John Biggerstaff is. It is correct, and it'll be undisputed, that Mario Fernandez went to school with John Biggerstaff's kids, his daughter and his son. And he's known him for decades. They both served in the military. They stayed friends. They worked out together at John Biggerstaff's house. John Biggerstaff also had a bit of a handyman business. You will not have to take our word for that. Because after this homicide had occurred, law enforcement was investigating Mario Fernandez. They put up what's called pole cameras. And those are exactly what they sound like. Cameras on top of poles used to surveil locations. You will be able to see John Biggerstaff doing work with Mario Fernandez at the Potomac rental property. You will see that legitimate work being done. In fact, it'll be a wet saw where they're doing tile work. Now, John Biggerstaff, who they will want you to believe is the person that provided the firearm in this homicide. John Biggerstaff did own a 10 millimeter. FDLE will come up on the witness stand and tell you they believe it's a Glock 10 millimeter. They'll also tell you that those have been in production since 1991 and that there's 3 models of Glock that's been produced. And he cannot identify which model it was. And Glock is a for-profit business. You'll hear they produced thousands of these firearms. But they're focused on John Biggerstaff's 10 millimeter. He did own one. The ATF did run what's called a firearm trace summary once they looked at John Biggerstaff. And in June of 2016, 6 years prior to the homicide, John Biggerstaff did purchase a 10 millimeter. It's a 40 Gen 4, probably. It's what's called a bear gun. It's generally used for hunting. But later in 2010, as the state mentioned, John Biggerstaff is arrested for a federal felony. And as a result of that, he was required to turn over all of his firearms. Starting in October of 2016 until the day that he dies, you will learn that he cannot possess firearms. It would be a federal and state crime if he were to possess firearms. But how will you know that he didn't have the firearm? Because his son will come in and testify that as a result of those release conditions, he helped fill out a firearms inventory, an affidavit, and I've highlighted number 7 on that affidavit, which will show you a Glock 40 Gen 4, 10 millimeter, with the serial number BBG-L770. Later that year, he becomes a convicted felon. John Biggerstaff will take the witness stand and said he did not possess a firearm. He will also tell you that they offered him immunity. And his statement remains the same. They didn't mention in their opening, but I anticipate you're going to see this evidence, that on January 25th, John Biggerstaff has some Google searches related to a 10 millimeter. He did. He once owned a 10 millimeter. Can't lawfully buy one or possess one, but you need to pay attention to what else he did not search. He did not search how to modify a firearm to throw off an analyst from FDLE on rifling characteristics or tool marks. As mentioned by the state, when these shell casings are ejected from a firearm, that FDLE analyst will tell you, we can tell it's a Glock because of certain markings. You won't see any searches of how to get rid of a firearm, how to stage a robbery for a murder, nothing. What you will see from the same exact day, it's also important to note Mario Fernandez is not there. You'll see that he searched the Windjammer Resort, the Average Savage, which is a band that apparently plays at that resort. He searches Charleston military bases. He searches 9 millimeters. There's not a 9 millimeter used in this case. You have to go into this with your eyes open and not focused like law enforcement was. You have to open up the aperture. You'll see that he searched locked gun case. You'll hear that John Biggerstaff has struggled with substance abuse and that he had a substance abuse problem during this time period. And I anticipate you'll hear that he hid drugs around his house. He searched his personal injury attorney. You'll have all this in evidence. You'll see that on the same day he searched handmade flour tortillas, certainly don't have anything to do with this case, luxury villas in Italy. You'll find out he doesn't have any money. You have to look at all of the evidence to determine whether the state meets their burden. But that 10 millimeter, where did it go? In 2016, Juan Biggerstaff will come in and testify that after filling out that affidavit, he then loaded 20 firearms into his vehicle. His dad said, you can keep 4. Didn't include the 10 millimeter, shotgun, rifle, a couple pistols. He takes them to his sister's house, Stephanie Atkinson, where they remain until she calls and says that she is buying a house. Juan, please come get the guns. He goes and retrieves the guns. He will take the witness stand and tell you, My dad never touched them. Also, he'll tell you, they offered him immunity, but that will be his testimony. Both of these men have been offered full immunity from prosecution in a homicide that has no statute of limitations. And their testimony will be, we have not seen those guns since 2017, because once he picks them up from his sister, he then has them. He's at UNF, Juan Biggerstaff, studying, and he gets recruited to be a police officer in Irvine, Texas. And on his way out of town, with the 16 guns that he doesn't get to keep, he goes to a family friend's house, Fred Martin, takes them in bags and in gun boxes, puts them in a closet. And both of those men's testimony will be, that is the last time they saw those guns. And the state will want you to believe this is part of some sort of conspiracy. John Biggerstaff has never been arrested. Juan Biggerstaff has never been arrested. They have been offered full immunity from prosecution in a first-degree murder case. And their testimony will be 5 years before the homicide was the last time we saw that gun. And FDLE will say, I cannot say that it's that gun. All I can say is it's 10 millimeter Glock, and there are thousands of them. Agent Blythe will come in and talk about timing advance records. As was mentioned, tracking plots on a map. And Mario goes to Potomac. That is his rental property. There will be no dispute of this. He goes there on January 29th. But you'll find out why he's there. As I mentioned, Henry Tennant, the man allegedly paid for this homicide, apparently can't afford the rent, and as Christina Stifler said, a rundown property on the other side of town. A man hired for a homicide who can't afford his rent is evicted from the property from the man who hired him to commit a homicide, is what they suggest the evidence will show. You will see a copy of the lease agreement between Mario Fernandez and Jeremy Ordway. You can use your own common sense about a landlord going to a property right before a new tenant moves in, and you'll hear testimony about it. And what Agent Blythe will tell you is that studies will suggest, and again, use your own common sense, that most people are within an arm's reach of their cellular device unless they're sitting on a jury, I suppose. But otherwise, the devices are near them or on them. But the state will try to suggest through the evidence that you'll see that Mario Fernandez travels with Henry Tennant, or I should say Henry Tennant's device, to Nocatee and then out to Jacksonville Beach on what they will likely refer to as a dry run, scoping out the scene in order to plan and premeditate this homicide that Henry Tennant committed. The evidence will show that Mario Fernandez's device is at Potomac. And in fact, Agent Blythe and any other law enforcement officer, they will not be able to say that Henry Tennant and Mario Fernandez actually saw each other, only that their devices were in the general area. But there will be no dispute that Henry Tennant's device travels south down 95, goes to the Nocatee area, the Beacon Lake area, and up to Jacksonville Beach, all while Mario Fernandez's device remains at his rental property. As to whether or not he goes to this rental property often, again, thank God for those poll cameras. You'll see Mario Fernandez countless times at his property, coming and going, tenants coming and going, air conditioning companies coming, him doing work at his property. There will be no dispute of that. Ms. Stifler mentioned that things were not rosy for Shanna Gardner and Mario Fernandez, and in fact, that was the case. You'll hear from administrators and teachers from the school that the twins attended, and they'll testify that yes, we were told things weren't going great. They'd done some marriage counseling, but things were rocky, and they anticipated getting divorced. They were going to get separated. This was at the beginning of the school year in January of 2022. But what they will also testify to is that Mario Fernandez, in this so-called marriage of convenience, was an active and involved stepfather. That he would attend parent-teacher conferences. And they'll tell you, despite what the state said about this acrimony in this child custody issue, is that it is very common. And they accommodate divorced couples. And they gladly do separate parent-teacher conferences. Not uncommon. This was not a result of just Shanna and Jared having problems. This is something that happens because far too many Americans do get divorced and do have to raise children. But they'll testify that Mario Fernandez helped with homework, school projects, he picked children up, he dropped children off. He was involved. February 15th, the day before the homicide. Mario Fernandez, once again, back to Potomac as he normally does. He is not an absentee landlord, he's involved. It's not a high profile, wonderful, beautiful house out at the beaches. It's a rental property for lower income people. And what he would do is go over and do work and try his best to make this property as best as he could. And he would hire people to help him. Henry Tenen will be there and leave. Again, there'll be no evidence submitted to you that there's any type of agreement, contract, solicitation, incitement, encouragement, nothing to suggest that Mario Fernandez has done anything to get Henry Tenen to commit this homicide. Mario Fernandez goes to John Biggerstaff's house. What the state did not tell you, but will be in evidence, is you will actually see why Mario Fernandez was there. You will hear testimony of why Mario Fernandez was there, because 4 days later, Juan Biggerstaff is getting married. He's going to be driving back from Texas with his fiance on February 16th and getting married on February 19th. And that Mario is going to help with tables and chairs. He drives a truck. Nothing nefarious about it. The state did not mention that in their opening, but the evidence will actually show you that. You'll hear from John and Juan, who will tell you, we've known Mario for decades. He was kind enough to help set up tables and chairs for the wedding that was going to occur 4 days later for a police officer and his new wife. There will be no evidence at all of a firearm or anything to suggest involvement in a homicide. Juan Biggerstaff will walk through that door. John Biggerstaff will walk through that door. They've never been arrested. Their story has always been the same, despite being offered that immunity. The night of the homicide. Agent Blythe will testify that Mario Fernandez's device enters Jacksonville Beach and goes to Marsh Inlet, and there'll be a lot of testimony about that. As to whether or not that device ever left that residence till 9:30 the next morning. Now, ladies and gentlemen, February 16th, 2022. It was a terrible day. There are a lot of people in this courtroom and a lot of people watching. That day destroyed the lives of so many people. We will never, ever say otherwise. What Henry Tenen did that night was unconscionable. And he will be held to account for that at a later date. The state has brought in evidence. Giant boots, car keys, jackets of Henry Tenen. He destroyed the life of Jared Bridegan, his wife, his family. He's destroyed the life of Mario Fernandez, who's been accused. There will be no evidence submitted to you that will connect those chains, that he had any involvement in what Henry Tenen did. Jared Bridegan came and picked up his children for his date night. You'll see video of this. It'll be heartbreaking knowing where that ends. He takes the children to a Jacksonville Beach barbecue place called the Bearded Pig. They're there for about 45 minutes. He drives them through Wendy's to get them Frosties. He drops them back off. You'll see videos. You'll watch them walk through the parking lot. And then you're going to also see videos of that blue truck owned by Henry Tennant, which will not be in dispute. These are little snapshots of all those videos that you will see. But what you will not see is Mario Fernandez. You'll see videos of that blue truck driving past people walking down the street. This thing gets blasted over the media. They are looking for any witness they can. There will be no witness, no evidence, nothing to suggest Mario Fernandez is in that truck. What you will see from 7:46 to 9:14, 7:46 is just shortly after dropping the twins off. You'll see the blue truck, as Ms. Stifler said, trying to give some distance. She's driving down 5th Avenue South through Sanctuary, turns into Fairway Lane. And you'll see that black VW Atlas driven by Jared Bridegan with his daughter in the back seat. And you'll see a muzzle flash. And you'll see a figure, which will be Henry Tennant. And you'll see video of him walking all the way from the homicide location down 9th Street, which is South Beach Parkway, and then turns into 9th, all the way down to Shetter, up Shetter, right past the police station. Ms. Stifler talked about coincidences. They do happen. You know why we know they happened? Because a terrible, ironic fact that you will see is that as Henry Tennant is walking past the police station after this murder, Kirsten Bridegan and I believe her mother show up at the police station. They are caught in the same frame. So ladies and gentlemen, you will see that coincidences do happen. Mario Fernandez can know a wrongdoer and not be a wrongdoer. The Stifler suggested that there's going to be data in this case that Agent Blythe will testify to that will suggest that Mario Fernandez had his cell phone off during the time of the homicide. However, what Agent Blythe is going to testify to is he cannot say that. He can say it's either off, airplane mode, or other. What's happening, timing advance is simply records produced by your cell phone carrier, and what it is to make sure your cell phone works, that you have good signal strength, and it knows when to hand off to another tower. But he's going to read to you a disclaimer from T-Mobile. Even if call records are found, there may be times when no timing advance records are available. Please exercise caution in using these records for investigative or prosecutorial purposes. What Ms. Stifler didn't mention, but the evidence will show, is there were other gaps. 12:05 to 12:43, and there's going to be a lot of gaps. You'll hear testimony. Mr. Dreiser will cross-examine Agent Blythe. There'll be another expert that will testify. This happens all the time. But the reason 12:05 to 12:43 will be significant is at 12:36, Detective Lamont and Detective Burrell from the Jacksonville Beach Police Department are now under the unfortunate task of notifying next of kin that Jared Bridegan had been killed. They will testify they left Jacks Beach Police Department at 12:36 and that Marsh Inlet is just a couple blocks down the street. And they show up during one of these gaps. But there's another gap. It happens almost instantaneously. 12:05 to 12:43, communicates for a second, then right back to 12:43 to 1:14 a.m. is what the data will suggest. And why you know Mario Fernandez is there is because those detectives will testify that they were standing right there speaking to him and Shanna Gardner in their house, identified by their driver's license. They weren't called in advance and said, we're on the way. And so when the state will be suggesting that that earlier gap was because Mario Fernandez turned his phone off during the homicide, you will actually have a conflict in the evidence from a detective that's going to say, I looked right at the man and his wife. Cell phone off, or is it simply an engineering gap? And you'll hear testimony, you'll be reminded of that disclaimer that they're not to be used for investigative and prosecutorial purposes, because sometimes they just don't exist. As Ms. Stifler mentioned, during the same time period, the scene is being processed. I anticipate you're going to hear from evidence technician Jarman from Jacksonville Beach, who's going to say, we're out there, we're collecting anything, we're putting placards on the ground. That's going to be in these boxes. You're going to take them back into the deliberation room. You'll be able to look at the shell casings, everything. They did find evidence that night of Henry Tenen. You're going to hear they found DNA on the tire placed in the road of Henry Tenen, not of Mario Fernandez. They swabbed everything. You're going to hear, in fact, we asked them to swab something. We have no burden. But we asked them at our own peril to swab something they found that wasn't tested. And there was no evidence of Mario Fernandez. No physical evidence. No witnesses. No videos. You'll be shocked how many videos you will see. They went door to door to door to door, getting every ring camera, every surveillance camera. They went to the Beaches Hospital to look at their cameras. They scoured everywhere they could for any video they could find, and they never once saw Mario Fernandez. The state will want you to believe during that gap that somehow he evaded every camera that nobody could possibly know where they are, but was never, ever seen. There's not a fingerprint, a hair, DNA, nothing, other than the killer, Henry Tenen. As I mentioned, the detectives go at 12:36. During one of those timing advance gaps, they'll testify that as trained law enforcement officers, again, you can use your own experience. They do patrol. Now they're detectives. One will be a corporal. They're trained to look at observations. They'll testify to the observations they made. They'll also testify to the lack of observations they made. Nothing of any evidentiary value occurred when they went to that residence, other than Shanna Gardner crying about having to tell her children and Mario Fernandez being present right there when that information is being disclosed. They will not testify that he hid in the back room. They will not testify that he was sweating profusely 4 hours after this homicide that he's supposed to be the mastermind of. They will give you no observations, other than we showed up, they were there, they answered the door. And yes, later that day, Mario Fernandez does what he said he was going to do. He goes to John Biggerstaff's house to help with the wedding. And you'll hear that from those witnesses. You'll hear that Mario Fernandez and Shanna Gardner go in for a voluntary interview. As the state said, there were deletions of Google information. They won't tell you what it is. They want it to be some sort of evidence of a homicide, but you can use your own common sense, your own experience. They'll testify, it could be deleting spam emails. It could be deleting pictures. It could be anything, but we can't tell you what it is. You have to look at this with your eyes wide open and use your own common sense. State did not mention this in their opening, but they, I anticipate, will make some sort of feature about this. Is that after the interview, Mario Fernandez goes on a road trip to Pennsylvania. But what you're going to hear is that he went with his truck, with his tag, with his cell phone, with his credit cards. State was correct. He had access to a lot of money, hundreds of thousands of dollars. There was no restriction on his travel. He could have gone right up the road to Jacksonville International Airport and fled the country. That's not what the evidence will show. So he drove north. He stopped, saw a buddy of his that he plays online video games with. You'll hear testimony, how they communicate over their headsets and sit in their gaming chairs. And they talk. They went out to dinner at Ruby Tuesdays. They did not talk about hide me from the police, switch cars with me, give me some cash, help me. No, they talked about trucks, video games, and work. They went to bed early because one of them had to get up early for work. Mario Fernandez carried on. He went to Walmart, he went to McDonald's, he used his cell phone, he used his credit card. They'll produce all that in evidence. It will not be evidence of a man running from the law. Several days later, he drives back. Straight route to Jacksonville. Right back to Jacksonville Beach, to his home that he shares with his wife, a couple blocks from the police station. And again, there will be no evidence that he's trying to disguise himself, hide his location, or anything. He goes right back to where the police came to see him the very first time. And then on March 9th, they released to the media the blue truck, blasted everywhere. Every news station, social media, every law enforcement officer in North Florida is looking for this blue truck. You'll see the videos of it driving through Jacksonville Beach. Then they start to look for the 10 millimeter. The state suggested that they looked everywhere. They went to a pawn shop in Jacksonville Beach. They went to Beach's Pawn on 3rd Street. They found 6 transactions for a gun that's not supposed to be that common. At a pawn shop, they found 6 of them. Henry Tenen was also going to a pawn shop. Guess what they didn't do at that pawn shop, which was look for a 10 millimeter. They did not expand this search. They looked in Jacksonville Beach, and they looked at Mario Fernandez, because as the state tried to say, who else would have the motive to do this? They don't know who's driving the truck. They don't know who actually solicited Henry Tenen. There'll be no evidence to suggest they do. It took them 30 minutes to get to Henry Tenen in their opening. Payments. They want you to believe that Henry Tenen was hired on credit. That a man that doesn't have 2 nickels to rub together, he makes $15,000 a year breaking down wooden pallets. He's evicted from the property that Mario Fernandez, the guy that's supposed to have hired him, they're going to suggest that he's been paid. He does get paid. He gets paid in the form of checks, 2 checks on the same day. One for landscaping, one for roof work. Boy, thank God for those poll cams. Because as much as the state wanted to say that this property just wasn't nice, didn't mean work didn't get done. And you're actually going to hear a recorded phone call that I'll get to in a moment that will actually hear Mario, not even knowing that he's being recorded, commenting on how good of a day laborer Henry Tenen is, and that this was during COVID, and that called out a contractor to take down a tree, and they wanted to charge $3,000 for one tree. You'll hear the phone call. It'll be in evidence, and you can listen to it in the back between 2 people who didn't know they were being recorded. But man, Henry Tenen, he's a workhorse. That guy tilled up the front yard, chopped down trees. You'll actually see video of him unloading tile from the back of his truck at Potomac doing work. And my law partner was nice enough to get up and grab a piece of evidence that you're going to have back there, which is a journal found in the truck of Henry Tenen. And the state said, oh, well, there's a check and it says Kickstarter, good luck. But we didn't find a Kickstarter account. Kickstarter just means that somebody's giving money to help kickstart somebody's business. Henry Tenen is a worker. Mario Fernandez has hired him to do work, not murder, tree work, roof work, landscaping, tile work. You're going to have Mr. Tenen's business plan because he wanted to be his own boss. You'll hear from his girlfriend. You'll hear from other people that say Henry wanted to start his own business. He wanted to do his own pallet business. He was tired of working for somebody else. He wanted to work for himself. And he wrote out a business plan that you'll be able to take back there and go through page by page with prices, what he anticipates his revenue to be. Mario Fernandez, who had at the time access to hundreds and hundreds and hundreds of thousands of dollars, gave money to a guy that had helped him around his own house and invest in his business that he wanted to start. That's what the checks say. That's what the poll cameras will show. You'll never see any tie to a homicide. And after that last check, you'll never see any other payments. They want you to believe that the evidence is going to show he got hired on credit and took 3 checks. They were hiding in plain sight. Mario Fernandez's name is on the check. The business, the LLC he has with his wife is at the top. It's got his account number. It's written to Henry Tenen. It's a contract for work, not for homicide. Mario Fernandez, Shanna Gardner go in for a second voluntary interview, and Mario Fernandez provides his DNA voluntarily. There's a jacket you can't see over in the corner. There's these boots down here. There's keys over here. Everything beautifully put in these boxes. They'll be great for Henry Tenen's trial. They have no relevance whatsoever for you to consider the elements in which you have to decide to see if the state has overcome their burden, because nothing on these connects to Mario Fernandez. Mario Fernandez could probably fit half his body in those boots. They will have no evidence to suggest it has anything to do with Mario Fernandez and the homicide of Jared Bridegan. Henry Tenen gets pulled over, as they said, was for investigative purposes. He gets arrested for driving on a suspended license. They find an old rusty shotgun in the trunk of the car. Has nothing to do with the homicide, but as they said, Henry Tenen's a convicted felon. He goes to jail. They go to Potomac. They notify Mr. Ordway that Henry Tenen has been arrested in connection to a homicide. They search Potomac. These are photographs from evidence technicians. You'll be able to look at them. How they determine these are the boots, that's for you guys to figure out, because you're going to see all sorts of different things they recovered from that residence, including the lease agreement between Jeremy Ordway and Mario Fernandez, signed on January 27th, when Henry Tenen, the so-called paid-for murderer, is getting evicted from the home of the guy that the state wants you to believe is paying him to commit a murder. Then the truck is recovered. There were likely a lot of high fives on that day. 2 ATF agents recovered this truck. This wasn't just a family friend of Henry Tenen. There's a man named Jimmy Jones. And this property is not owned by Mario Fernandez. It is not a rental property owned by Mario Fernandez. There will be no evidence to suggest that Mario Fernandez has ever been to that property at all. They talked to this man. Oh man, Henry, he rolled this thing up into my yard, said the timing chain was broke, don't work anymore. A man hired for a homicide apparently couldn't afford to fix his own truck, and it's sitting in the backyard. They get a search warrant to recover the truck out of the backyard. But the evidence will suggest they didn't need to get the search warrant because Jimmy Jones said, sure guys, go in the backyard, you're welcome to get it. Hey, if y'all want to search my house, feel free to do it. They have now found the truck used in the murder of Jared Bridegan. They do not have a firearm. Guess what they did not do? They did not search the property. They didn't go in despite having consent. They'll say, well, we didn't have a search warrant. You don't need a search warrant. Law enforcement will tell you if they have consent, they can go right in. And that consent can be revoked at any time. Jimmy Jones said, guys, come on in. He said, did Henry get caught up in a shooting? And yet they decided not to go look for that 10 millimeter in the very location that they found the truck with a guy who did not call law enforcement and say, I've seen this truck all over the news. It's in my backyard. But what you're also going to hear And why it's significant is when FDLE takes the witness stand, that agent will tell you on July 30th, just a couple weeks ago, we're still getting evidence. He produces a report identifying the firearm used as being a Glock, has 4 names listed on that report: Henry Tenen, Shanna Gardner, Mario Fernandez, and Jimmy Jones. This was not a good investigation. Ms. Stifler was right. It was by officers who were not experienced in homicide investigations. They will tell you they were learning on the job. We'll never know what is inside that house. So when they say, oh, I wish we could have got the gun, maybe we could have exonerated the idea of it being Mr. Biggerstaff's gun, there were opportunities. They only looked where they wanted to look. They did not look in a house that they were given consent to look. They recover the truck. They take it to Jacksonville Beach. They're going to tell you they didn't even want to keep it in their garage. It was so disgusting. So if your mind is, well, maybe the truck was scrubbed and that's why they didn't find any evidence. It's what the state will want you to believe. They're going to tell you it was so disgusting that when they pulled items like this book out, they would shake it and there would be things from rodents, from bugs. And it was disgusting. And they vacuum it with special vacuums, with special filters, looking for hairs and DNA. Mario Fernandez isn't like me. He's got a head full of hair. They didn't find one hair, one fingerprint, DNA, skin cell, anything. Nothing related to Mario Fernandez. The active wiretap I mentioned, you're going to hear it. A witness named Carlos Fong, he goes by Sonny. He's a friend of Mario Fernandez. He sees on the news about this homicide. And it was Shanna Gardner's ex-husband. You're going to hear these recordings. Oh my God. Yeah, me and Shanna, getting separated. It's terrible. He's going to say, yeah, I still drive the truck. Oh, it's a nice truck. They talk a lot about trucks and why he likes his Toyota. Talks about his dogs. Why I mention the dogs is because the trip to Pennsylvania, the state will likely make a big deal of. He didn't take his beloved dogs. You'll hear on the phone call, man, my dog has outlived his life expectancy. But I'll tell you, when I get him up and moving, he's great. And he also talks about Henry Tenen. Man, you know Henry Tenen? He doesn't distance himself because, yeah, guy did all sorts of work for me. Chopping down trees and tilling up the front yard and doing landscaping. He was a workhorse. You'll hear the phone call of 2 people that did not know they were being recorded. They eventually search Mario's vehicle. They seize his phone. No evidentiary value. Now, ladies and gentlemen, as I started this opening, as you started your jury selection and you heard the indictment being read, the state of Florida has the sole and exclusive burden to prove each of these elements. Element 1 will not require any proof. And I should take a moment and tell you, there's going to be lots of witnesses called in this case, specifically to do what the state is required to do, which is an order of proof. Unfortunately, they have to prove that Jared Bridegan is dead. So when there are witnesses that take this stand and Judge Kite looks over and says, Mr. Hill, Mr. Dreiser, any cross-examination, and we say no, trust me, we could get up and talk for hours and ask all sorts of questions, but you've devoted 3 weeks of your life to answering these questions. So if we do not get up and ask questions, because there is no evidentiary value for answering these questions for Mario Fernandez. We will not need to ask questions of the really kind citizens that comforted that little girl in the back seat. We will not have to ask questions of the law enforcement officers trying to give CPR. We certainly will not have to ask questions of the medical examiner who determined the death of Jared Bridegan. When we do ask questions, we ask that you pay attention. And I know you will. You've committed so much to this. The only questions you have to answer is not, was this a terrible night that has scarred so many people? You have to answer these questions, which is that the death was caused by the criminal act of Mario Enrique Fernandez Saldana, whether or not it was premeditated killing of Jared Bridegan. You will certainly find that Henry Tenen did exactly that. They will show you all that evidence. But you will have to determine whether or not Mr. Fernandez intended for that murder to occur, and whether he did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person, Henry Tennant, or others to commit this crime. They don't have to prove he was there, but they have to prove those two elements, both of them, in order to convict him. As to criminal solicitation, the burden rests at this table to prove that Mario Fernandez Saldana solicited Henry Tennant, the murderer, to commit an offense to which first-degree murder, and that during the solicitation that Mario Enrique Fernandez Saldana commanded, encouraged, hired, requested Henry Tennant to engage in specific conduct which would constitute the commission of first-degree murder. That is their burden, to prove beyond and to the exclusion of a reasonable doubt. And the judge will read you this instruction. You will carry it with you back there. We talked about it in jury selection. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent right now, innocent. This presumption stays with the defendant as to each material allegation in the indictment through each stage of this trial, unless it has been overcome by the evidence to the exclusion and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The law does not require proof beyond all doubt on the part of the jury before it returns a verdict of guilty. A mere possible, speculative, imaginary, or forced doubt is not a reasonable doubt. A reasonable doubt is not a guess or mere conjecture. Rather, it is based upon the reasoning, common sense, after careful consideration, impartial consideration of all the evidence in this case. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If, after careful and impartial consideration of all the evidence, you have a reasonable doubt as to the guilt of the accused, it is your duty to find him not guilty. On the other hand, if after careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant guilty. It is to the evidence introduced at trial and to it alone you are to look for that proof. You have to be convinced that he did each element of each charge. Otherwise, as you stated in jury selection, it is your duty, it is the law that you would return a verdict of not guilty. Ladies and gentlemen, you have paid attention to me, you've paid attention to the state, you sacrificed all last week. In the next 2 weeks, we don't want to waste any more of your time. Thank you so much for your attention, and we look forward to showing you our case. Thank you.
Thank you, Mr. Hill. Members of the jury, it is noon. We will take our lunch recess at this time. Please leave your notepads on your chair. You're going to retire to the jury room and we'll bring it out as soon as we have it set up, okay? Court's in recess.